Welcome everyone to Global Regulation Frameworks, LegalBlock Global Regulation Frameworks, this time with Giulia talking about Italy. Giulia, please introduce yourself to the people here. Talk us about you.
I'm Giulia Arangüena, Giuara from my dearest LegalBlock trainers, an Italian lawyer enrolled in the Rome bar. I'm founder of the ADLP law firm and currently also in charge of the anti-money laundering and compliance section of my mom. Sorry, of the anti-money laundering function of a Maltese institution secondary branch that's offering services to active operators in the blockchain sector. I've already a scholarship from the computer science department of the University of Turin for the blockchain and local financial instruments. And I teach fintech and blockchain topics in an university master's degree at the University of Pisa as part of the e-finance module. I'm dealing with blockchain issues since 2013. And I've written some monographs, several articles and posts, and I also participated as speakers to numerous events and conferences in Italy organized on the topic related to the blockchain.
That's interesting about your profile, Giulia, that obviously you are a woman. And you start early on that women have, family and kids, and sometimes you have this whole, like waiting for because you have a baby or whatever. Has been your case because you are one of the ones who start early.
Because I didn't have a baby. So I was wondering at the early stage to occupy my time. No, I'm joking. I left Siemens in Italian practice on more or less, I think, 2010. And I began starting the profession like an entrepreneur. So I built a blog, my digital legal profile, and I intercepted Bitcoin like keywords. So in order to read a post, I said to my young colleague, please write down a draft of post, because I realized that word was very hot, Then she had done her proposal of post, and in the revision, I fell in love with Bitcoin. I organized a sort of task force with my youngest colleague. We made some Twitter fake profile to follow the lines to which these particular kind of keywords driven. And so I discovered the planet of Bitcoin. We collected a mountain of material, and we start to draft our first monographs on 2013. And after the first judgment of Texas, I decided to link my name to the cryptos.
Sure,
So that here I am.
Okay. Okay, and you have been working always in Italy. Give us an update.
In Italy with some little period abroad. In England with Siemens and around the world, because as you know, Siemens was one of the big five law firm, and so I was forced to wander.
Okay. And
Okay.
right now we understand the European Union is the European Union. What is particular about Italy, or what is going on in Italy right now?
That
Can you hear me? Yeah, can you hear me?
Oh yes, but the connection isn't.
It's not good. Okay, let's.
Good enough. It's good enough. Let me start, please. Yes, because what I want to talk about today is the state of the Italian regulation in the blockchain sector, and how the entire Italian legal system is moving to welcome, from an economic and a legal point of view, the blockchain industry. First of all, I give you an intro with some very general aspect of the current regulatory context of DLT technology in Italy. So take into account the following 5 points. First, Italy moved quickly enough, starting from the approach that the European Union has begun with the first ECB report of October 2012, the famous ECB report, the first official document of a regulatory authority on cryptocurrencies. Then Italy moved within the lines of a sustainable and viable regulation, following what the friendly but prudent attitude expressed by the ECB was. Italy, in fact, privileged and the alternative and the voluntary monetary nature of cryptocurrencies, with within the perspective that has caged the European Court of Justice with the first ruling on the VAT treatment of Bitcoin over 1215. So defining cryptographic token as virtual currencies intended as means of payment without legal tender. Although the broad convergence over their monetary nature in Italy, the virtual currency might involve different regulatory risks in Italy. Consider, for example, what happened in 2017 for some decision taken by CONSOB, our National Commission for Listed Companies and the Stock Exchange, respectively under the Consumers Protection or under Financial Instruments Law. That could lead to an increase of registration and information duty to professionals. In any case, and it will be the last part of this presentation, with the current government Italy is clearly supporting initiatives for the development of a public policy for the blockchain sector, which will have to develop a national strategy and design changes and further regulatory measures more significant than those hitherto assumed within a more systematic scenario. Given the ball, we tried to go a little bit deeper by drawing a sort of roadmap with all the fundamental steps made by the Italian legal system in blockchain matters. So let me track the Italian blockchain regulatory roadmap, easily formed by 10 steps. On January 2015, Bank of Italy issued the first warning to consumers regarding risk related to the lack of protections and tax implications of cryptocurrencies use. Soon after the CJEU first Bitcoin ruling on 2015, Italian Revenue Agency, Agenzia delle Entrate, on September 2016, released a resolution about VAT and about the 51,000 euros yearly cap of capital gain exemptions. In the 2017, Verona Civil Court has examined a case relating to a transaction based on cryptocurrencies and considered that the Consumer Protection Act applies to it as an online offer of investment instruments. Then, the most important regulatory measure is the legislative decree number 19 of May 2017 that defined virtual currencies and subjected virtual currencies provider to the regulations established for the traditional money exchange operators and to the AML legal discipline, meanwhile wholly reformed by the same legislative decree. To that effect, legislative decree number 90 charged the Minister of the Economy and Finance to issue a ministerial decree setting forth the modalities and timelines for the proper performance of virtual exchange activities throughout the country. Accordingly, the Ministry of Economy and Finance published a public notice requesting comment on the proposed text on the ministerial decree, and it is expected that the ministerial order will be issued during the upcoming month. But on last April 2018, another statement for the Italian Revenue Agency has established how that incomes deriving from virtual assets must be accounted for and declared within the annual income certification. And on last May, it has been formalized a political commitment to an introduction of blockchain in the economic field of the country by the government agreement entered into from the political forces that won the past elections. On September, Italy has signed the Blockchain EU partnership and launched a call of experts to help the Minister of the Economic Development to design a national blockchain strategy. And on October, few weeks ago, in a draft to the fiscal decree, which will have to accompany the forthcoming economic maneuver in presentation in this day, a proposal for a rule has been inserted. Very, very important. This proposal, by the principle of a technological neutrality, confers to all data and information recorded with ADLP technology the same validity and the same legal strength of a data certification made with other technologies. The main implications regarding a market opening for blockchain application to certify the authenticity of legal documents and contracts, the digital identity, and so on are evident. Just as obvious is all the implication that will involve the possible approval of this standard proposal on the current structure of our public administration and on our code of digital administration based on an old concept of IT document and a strong digital signature. Well, take a breath. This was the scenario. Now, if you want, after this quick and quite heavy roundup of information, let's take a breath to go forward more in detail.
Okay, let's see what we have here. We have first the Minister of Economy and Finance just issued a call to experts to work in September, right? To start working on this
September.
session. Okay, that, for example, we have people here, like I know Steve is around and he has been part of these conversations, task force with regulator in his territory, as well as Joy. We had Joy in Gibraltar as well. Okay, so what we have clear here is that we have the data certification is very interesting to me. I don't know if for everyone is interested, but that explanation, I kind of like it. Okay, you got that. Okay, so talk us about what is the pipeline, or what is next, or what is important.
It is just a proposal, all right? But exists. Let's see what will happen. That day, okay.
Yes, go ahead. I'm muted just to.
Okay, okay. Yes. Well, we trace the lines in which the Italian legal system has been moved, and the milestones we have covered over the years to bring out cryptocurrencies and the blockchain in our legal system. Now let's examine the most relevant Italian regulatory measures. That is Legislative Decree number 90 of May 2017. We have to start from what it is doubtfully the most crucial regulatory measure, because it's very important and because is a primary law of the state. All right. Shortly before the European Parliament approved the modification of the AML4 directive with provisions regarding the virtual currency use, Italy has anticipated some rules of the directive with the said legislative decree, including exchanger as an obliged entity for AML purposes, completely reforming our own national anti-money laundering discipline. The first important thing that has made by the Legislative Decree 19 is to define through a regulatory provision of primary grade what are the virtual currencies are. These were identified as the EBA opinion of 24-1, like a digital representation of value that is neither issued by a central bank or public authority, nor necessarily linked to a legal tender, but is used by natural or legal persons as a means of exchange for the purchase of goods and services, and that can be transferred, stored, or traded electronically. The further important thing that the Legislative Decree 19 has made is to define the business provider as any natural or legal person providing professional service to third parties functional to the utilization, the exchange, or the storage of virtual currencies, and to their conversion from or in currencies having a legal tender. Then legislative decree has divided the AML obliged entity into different categories, including the service providers engaged in the use of virtual currencies limited to the conversion of the virtual currency from or to legal tender currency in the category of non-financial operators. In detail, the AML Italian reform, based on the legislative decree, has limited the AML obligations to only the exchanger platforms, becoming the very first European national legal framework that has introduced rules with a first-level regulation on virtual money exchanger. And moreover, under the Italian legal perspective, the virtual currency exchanger became a self-standing operator, but in all respects equated to the traditional money exchangers. In fact, in this regard, the most relevant thing to be noted is that the Italian choice was to extend to the virtual currency exchanger the relative light legal status that has a normal exchanger that operates with foreign currencies. That as early as 2010, with the structural reform of our credit system, is no longer considered financial intermediary, but a merely commercial operator. Requested to request only a standard commercial license as a coffee shop. The only difference is with an average commercial operator established by legislative decree on the virtual currency exchanger are the obligation to register its economic activity in a special section of the public register of money changers held by a minor authority called OAM, that is an administrative body independent from Bank of Italy and without any banking powers, and to observe some of the most relevant AML obligations. So, in short, under the legislative decree, there is no type of a special license for exchange to be requested, and no authorization to perform, but only some administrative obligation to require registration in a public list of active operators. While as for the AML obligation to which the virtual currency exchanger I held, these are the classic ones of the discipline, the identification of clients, and so on. I think that is very, very okay. Ci state, okay. I think that is very important, this kind of regulation, because insert exchange in a very light regulation provisions. And as said before, in the tracking, the Italian regulatory map, the legislative decree 19 charged the Minister of the Economy and Finance, MEF, to issue a second regulatory level measure through a ministerial order setting for the modalities and timelines for the proper performance of virtual exchangers activity within the country. Accordingly, the EMF, in last February, has published a public notice with a call for comments on the draft of the ministerial order proposed scheme, and it is expected that it will be issued in the final test during the upcoming month. the release scheme of the ministerial decree aims to allow the government to monitor virtual currencies phenomena and authorities to obtain data to conduct investigation to contrast money laundering and terrorist threats, and to require to virtual currencies related service provider to register themselves in an IMF selected list, sending a certified email to which include an electronic sign-up form, a communication of the beginning of activities in the country, and personal or company's detail and documents. The proposed ministerial measure was sharply criticized in Italy for the fact that it surpassed a little bit the criteria of the legislative decree, also trying to oblige the merchants available to accept payments in virtual currencies to denounce the beginning of the activity with the official communication to the IMF. So it will be confirmed in the official version of the proposed ministerial order. It could entail an appeal before the administrative courts for the excess of legislative delegation. But in any case, since last February, the public consultation was ended, and it has not yet been issued, the final text of this ministerial decree. And some sources confirmed that before releasing the final version of the proposed ministerial decree, it is waiting for the implementation of the 5th AML directing our legal system. So we have to wait for. Are you alive? It's very boring.
No. I'm just. I just listened to the Minister of Economy and Finance, and through a ministerial decree is the regulator entity. Is how many actors do you have in terms of regulation in Italy? Because when we talk about, we talk about this. We just had last week. The blockchain summit Latam in Bogota, and the panel of regulation was great because it was all members of LegalBlock, by the way. And we had there Luis from New York talking about the US. We had Carlos from Mexico talking about the fintech law in Mexico. We have Daniel and Albi, whatever. They said during the panel that they talk about how many entities and people and actors are involved in the regulation, at least in those countries that make the process sometimes very inefficient. So everybody was talking about their countries, and here we're talking always about the Minister of Economy. Tell us about how it works.
You mute yourself.
Yes, I just ask and mute myself.
Okay. Well, we are in a civil law country. Then we have the ancient theory of the various sources of law. Okay. The sources of the law, first of all, is the parliament with the law, and then all the administrative body of the state, of course. So then it's complex. The situation is complex. Yeah,
it's crazy what we have seen in other countries, but well, Albi was on the panel. I were not there, but I remember Carlos talking about the entity in charge in Mexico, and correct me if it's not like this, Albi, was the Bank of Mexico in charge of the taxonomy of the tokens. So
yeah.
Okay.
Yeah. I think that the question that Maria wants to ask is just how many authorities. I mean, in terms of you have one in taxation, another, for example, in the capital market sector with some competence, and you have central bank in the other side. You have for consumer protection and other authorities. I mean, we have a lot of bodies in charge or trying to control every side of the regulation, and this is a complex situation in our civil systems that as everybody knows, has to respect formal law as a framework, but when, yeah.
But the same faith, the same destination have the countries of common law. Because USA, for example, has SEC as a source of the law.
Correct. Correct. That was of the panel things that we were talking about.
Yeah.
But one thing that I want to, that I would like to know more about the one thing that you said before about the kind of license that the new regulation or the current regulation is establishing, that is not a non-financial institution. I mean, is because one of the problems that our countries have is that the money transmitter license, as you have in US, is not common in countries, decentralized countries like Spain, like Italy or Latin America, or every country in Latin America, because I know you don't supposed to move money between different states with some authority, local authority. I mean, in this topic, you said that one of the new position is to categorize the exchanges as a non-financial institution with different requirements and level of specific compliance requirements. That is not the typical that the financial institution has in the AML sector, which is considering that you have to allow innovation, you have to understand, and you have to see how this market is evolving, how this market is going on. Okay, and not pretending to say, okay, let's do a big law with those specific and strict regulations. Like, for example, you have in Mexico, where the central bank has authority now to decide which token would be utility token or security token or whatever. When those authorities are not familiar with that technology, those authorities are not close and familiar with how fast the technology is going on. I would like to see more your impression about how the Italian system is approaching this very complex situation with different levels.
Oh, well, I think, as I said briefly in my the intro, Italy is moving toward a sustainable and viable regulation. For the exchanger, for example, Italy's choice was to limit this kind of operator, equating to traditional money exchanger. Okay, I mean, I'm talking about only the exchanger that offer to a public a normal trade contract without any consideration about, for example, margin trading, because the margin trading could be involved some regulatory risk. But talking about only the trade contract, the trade to buy and sell, and for the conversion of cryptocurrencies in or to from legal tender. Our legal system prefer to consider crypto exchanger as well as normal and traditional money exchanger. Our legal system imagine a very light legal status, and for example, the status require only a normal license of commerce. Okay. If you want to open a coffee shop in a street, you have to ask a license to operate to the public, of course. That is the same thing, okay? And the other thing is to denounce the beginning of the activity with an email to the EMF. And the well, and then an exchanger has to request the insertion in a special part of a public register. All right, and stop. We didn't have had the same mistake of New York with the Bitcoin license, all right?
Okay, got it. Yeah, sorry, Tete.
No, I'm just saying that's because we have just like 5 minutes to go. What are the best or the advantages of Italy in terms of regulations? So if it's friendly, or what do you see? You can be critic as well, because you have your skin on the game. You can say this is good, this is bad. I mean, here we don't give legal advice in these sessions, as you know. We don't sell any services, so we are just exchanging opinion. Okay, and obviously with a guest of the jurisdiction that is knowledgeable about. So you can be critic, and maybe what is the advantage you see in Italy? What do you see you are behind or beyond?
Another advantage for our legal system, I think, is in the fiscal, because we have had two ruling on 2016 and 2018 that confer a legal certainty, exemptions, and guidelines to for the individuals that deal with cryptocurrencies and digital assets, for example. I think that this is a heavy advantage. The fiscal situation of virtual currency in Italy is very complex, because there have already been two measures, all right? This chapter of the Italian regulation on blockchain should be devoted to an adequate investigation, also because Italy offers a very friendly tax treatment and various other fiscal possibility to incentivize and attract business concerning the use of cryptocurrencies. I'm not a tax law specialist, and I can now only give you a very general picture, if you want, on the Italian tax situation. I invited Stefano Caraccioli, Tete, but unfortunately we didn't match the hour for the call. but I think that if you, as LegalBlock, decided to organize some panels with a global tax law and legal frameworks about digital assets, I think that Italy could say something very friendly about it. If you want, I will pass to examine other part of our Italian legal system, because I would like to talk about some regulatory risk deriving from consumers protection and securities and financial instrument discipline, if you want. Because I think that providing a regulatory risk framework currently in place here in Italy is important, because some indirect, very useful legal aspects are derived from, example, in the area of ICOs. In fact,
okay, that's sorry, yeah. That's important. That's very important. For the time, we have like in the chat some things. Maybe we can do two parts of this. I mean, right now, and then we move to the other part. So we have this, all the sessions in the same time frame. But just here, there's just to clarify about the Mexican comment. Here is, I'm not sure if it's Carlos or is other person, but it's a legal paradox. Only to clarify, the attribution of the Mexican Central Bank is to determine the virtual assets that could be transacted from financial institutions. That's a clarification about the Mexican. Here, Francesco has a question, maybe a comment. What we can do is read it from Francesco, and we stop, and then we keep going with the second part. Okay, so let's do like this. Francesco, I read that in Turin there was a property purchase in Bitcoin registered by a public notary. Do you think that this is just one isolated case, or it will be the first of many? Sorry. And also, do you think that Italy is ready for the smart contracts? This question for our opinion.
Oh, well, not so ready, all right, but not so ready, but we have the lines of a development already present in our legal system that trace a precise trajectory on which Italy is going on. And I think that it could be said openly that Italy is encouraging as much as possible the innovation of the blockchain and its impact on the various economic sectors of application. I mean, Italy was initially absent from the liaison between several European countries last April, okay, to give life to the EU blockchain partnership and so on, due to the past election and the uncertainty that accompanied the birth of the current government. But as I said, on April, there was the government contract entered by the political forces that won the election and that gave life to this government, in which the blockchain was inserted as a precise objective of the government program. And from that moment, we are having many details of this path. because on last September, Italy signed the European Alliance and immediately after launched the call of blockchain expert. Okay. In addition, there are now proposals for rules presented during the financial maneuver under discussion for the next exercise of the public accounts, which mark even more the path outlined by Italy. In this regard, for example, is the case of observing that there are a proposal to insert a standard that allows the application of a sandbox regulation on all the fintech and blockchain subject that had already been proposed last year and by some stakeholder interested in crowdfunding reform, and which we hope will pass before or then in some normative provision. Then there is the possibility to setting up a public fund managed by Cassa Depositi e Prestiti to encourage startup in the fintech and blockchain areas. Then there is the proposal included in one of the decree implementing the financial maneuver this year, which aims to adequate the data recorded with ADLP to a digital information and data recorded through the other technology. Well, in short, Italy has started up, and we hope we can complete an entire frame of favor towards blockchain innovation from here to the next 5 years, I think. But let's not forget that Italy is already equipped with a regulatory element of sufficient legal certainty to allow the development of economic initiatives related to the use of DLT. And I hope that this could happen in my country. And returning to Francesco's question, I think that the Turing case won't be an isolated case. So rumors and various sources that I have contacted in this period indicated Turing as a blockchain hub for the country, for example. Let's see what will happen.
Okay.
We're here.
Okay, so thank you very much. We're going with part 2. Don't go anywhere. Okay, thank you, Giulia, for all your insight. And see you next time. Okay, bye-bye.